session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number 1, CACV 16-0385, Sarah del SERONDE. SERONDE, is that right? SERONDE? Okay. Et al. Versus BNSF Railway Company et al. Council, remind you that this argument is being video and audio recorded, and so we'd ask you to please identify yourselves and who you represent at the beginning of your arguments. Each side will have 20 minutes. Council, for appellant, you may watch the clock and reserve as much time as you deem appropriate for rebuttal. Also, please keep in mind we've read the briefs, we've conferenced the case, and with that, Council, you may proceed.
Thank you.
May it please the court and counsel, given the fact that the court is familiar with the briefing, the facts of the case, what I wanted to do is step back and point out what I believe to be the biggest issue in this case is what area of law either party wants you to start your analysis from. The railroad would want you to start the analysis from possessors and owners of real estate and the duties that flow therewith. Plaintiffs, appellants, which, by the way, I'm Bob Potroff for appellants, plaintiffs.
Thank you.
I get a little too excited to go. We would want you to look at this as a railroad crossing case because there is a difference. Yes, at one point in time, the analysis of possessors and owners of real estate governed railroad law, but the area of railroad crossing law has evolved because of several items. Number one, people have to cross railroad tracks. If you're in rural America, you've probably run onto railroad tracks and have to go across them. If you're going to exercise your right to travel, you're going to cross railroad tracks. Railroads have evolved into a duty to provide reasonable and adequate crossings for the public. The trains that run up and down their tracks create a specific set of hazards that are unique to railroads. So the law followed those givens that there is a right to travel, there is a need for crossings, and there are specific hazards, and has developed an entirely separate area of law for railroad crossings. Now, there are certain parts of the law that are in common, and the first part is the one that is continuous trespass upon a limited area. I've learned that in law school. It's present in virtually every state. The continuous trespass upon a limited area, which we run into in railroad cases with we call it a rabbit path or a beaten path or a trail that goes across the tracks. That's the same law that applies in continuous trespass in a limited area for a normal possessor of land, that there is no duty owed to anybody that comes on your land unless and until you're aware that there is a continuous trespass on a limited area, either by seeing the continuous trespass or evidence of the continuous trespass, i.e. a trail. And that's the Southern Pacific versus Bolin case. In Arizona, the Southern Pacific versus Bolin case recognized where a young man followed a beaten path.
And I'm familiar with Bolin. In Bolin, you're talking about a pedestrian on a traveled path. This involves a roadway that ends in two gated fences that is not used to access anything. In Bolin, it was the south of the town to the business area of the town. In this case, you have a road that doesn't access anything unless you have a key to the gate, which is Forest Service, or you have a key to the gate to the neighbor. I don't know what her name is, but her house.
Right.
So how do you differentiate between a regular route of travel, meaning lots of people go there to access something, and this doesn't access anything unless you have a private interest?
First of all, factually, yes, this is on the other side of this crossing, not the side that the plaintiff and the deceased approached from. On the other side, there are two gates, but there's also a shortcut that takes you all the way back to the highway. And some people, and even in the appellee's brief, you will see they acknowledge that most people turn around at that dry wash because it's a sandy riverbed, but the trail goes on through and continues. And there's actually houses, at least one house, on the other side of this road, which is an access road back and forth for that house. So it is, and that's the perfect question is, so what are we looking for? In railroad crossing law, we're looking to determine, does this railroad know or should have reason to know that there may be people here? Not a specific class of people, but people. And the Boland case says, trespasser, licensee, invitee doesn't matter. And that law is carried on in the additional cases of Beasley and Delgado, that it doesn't matter what the status of the person is, it is, does the railroad know that there are people going to be there?
And I think it says persistently intrude upon some particular place within the land is what Beasley says. So if you've got people using that crossing, you've got 55 people a day using that crossing, and all 55 are licensees, does that ruin your argument?
Well, I don't think it does. No, because I want to break into the two areas of law. The continuing trespasses upon a limited area is the law that we talk about consistently and persistently. All that does, that law establishes that the railroad knows there's a crossing.
It doesn't just require that they know it's a crossing. It requires that the people using the crossing are not licensees, are not authorized by the landowner to use it. Agreed?
No, I don't think so. The duty belongs to the railroad. The duty of the railroad is based upon its knowledge that there are people using that crossing.
And when you say people using that crossing, you can give a license to somebody using the crossing.
You can.
And that doesn't add to continually and persistently intruding upon because it's with permission.
This is very similar to what happened in the Boland case, that this was actually another industry that may or may not have been giving permission to someone else. And the fact that you give some people permission and others don't, we don't know who had permission at this crossing and who didn't. We do know that it was being used by at least a half a dozen people that day. We know that it was used by an owner of a house on the other side. We know it was used by drivers and passengers to access the petrified forest and other places. What we do know is if you skip to the Garcia case, the case where an illegal crossing was put in, but it was being used by people, and the railroad said we don't have a duty because it's an illegal crossing. When they put up signs at that crossing, the duty became a duty to reasonably exercise reasonable care under all circumstances. Now, I want to step back a little bit because this is not unlike the restatement of torts at 324A. Once a railroad elects to put in a crossing, they don't have to put in a crossing that is for anybody. Unless a public entity requires it, then they're forced at public crossings, and we have a whole body of federal and state law that says you have to do certain things at public crossings. We now have, and we have Boland and the Garcia cases that say even if they're not public crossings, you're going to have the duties to continuous trespassers on a limited area. The third category is what happens if they voluntarily agree to put in a crossing? The railroad wants you to make a ruling that says there's a black line that says all we have to do is not intentionally or willfully or wantonly hurt somebody. That's not what the restatement says. If you voluntarily undertake to put in a crossing for people, you need to do it with reasonable care. That is the consistency of this case with railroad crossing law. And that's why I cited so many cases from other jurisdictions, is because this is not a situation where we're trying to prove that this railroad knew or should have known people cross here. They know they crossed here. They put in a crossing themselves. They put up signs themselves.
But doesn't the knowledge of what kind of people are crossing dictate what type of crossing it needs to be?
And that could be. That could well be. But here's what we don't know. We know 55 a day is what they report. We don't know.
55 day, but they also reported it was a private crossing.
Right, as there are literally thousands.
Is there any evidence in the record of how many of those 55 were trespassers?
No, that is absolutely a question of fact. There is no question it's a question of fact.
Okay. How are you going to develop that question of fact?
Well, at trial, we will develop that we know that twice a week railroaders use it, or sometimes 3 or 4 times a week. And that's when they do their track inspections. They don't have any other reason to use it. They don't have.
They're trespassers?
No. Those would be.
What quantity? Could you prove that one trespasser uses it per month?
Well, we're assuming that if they're going to call these trespassers, that there's 50. Because the one person a day that lives on the other side, she would technically be a trespasser too, because she doesn't have a license agreement and doesn't have permission. She just uses that crossing to get to and from her house. So the only people that we know in this record that are railroad employees that use it are the maintenance people who set their vehicles on and off 2 or 3 times a week. And the others, the railroad knows who the other 50 are. We don't.
Just trying to understand your argument as to what the railroad is supposed to anticipate. Are they supposed to anticipate weekend traffic for four-wheeling, ATV activity? Are they? I mean, or would that need to be present? There had to be seen first, and then they could anticipate that there would be ATV traffic out there on a regular basis. At what point or is that your argument is saying reasonable care applies in all instances, doesn't matter anything else? Nothing else matters. Is that your argument?
My argument is reasonable care under all circumstances, and that is a flexible standard that applies and it works in all situations. What we have here is we know this railroad has reported 55 a day. They won't tell us who the 55 are. They have not been able to establish that it's all railroad employees. There's no suggestion that it's all employees from someone else. What we do know is we saw on the video there's another vehicle in front of this row of cars on the other side of the wash. All I know is they acknowledge that there's 55 and they put in a crossing. And what I'm suggesting to this court is that the law of negligence, which has been effective for literally centuries, is effective in having reasonable care under all circumstances be the standard of care here. If we don't do that, we're going to say that somebody who walks over a fence, cuts through the fence, walks on that dirt trail that Mr. Boland was on, and gets hit by a train, is entitled to reasonable care. But someone who uses a crossing that's marked like a public crossing, that you have no way on earth you can tell that it's not a public crossing, has a black letter law that says we just prevent ourselves from injuring or killing you willfully or wantonly. And that doesn't make sense. What makes sense is to have that standard that allows for all circumstances to be weighed by a trier of fact, and that's all we're asking for.
Any questions?
Thank you.
Thank you. Thank you, counsel.
May it please the court and counsel, my name is Bill Thorpe. I represent BNSF Railway Company. I'd like to first address the question that Judge Campbell raised and then followed up by Judge Brown. There is no evidence in this record that any trespasser ever went across this crossing. To Judge Campbell's point, yes, there are two places you go across. To the south, there are two gates. To the left, you go and there's a wash, and there's no place to go through the wash. Despite what Mr. Pochoff just said about people gaining access to the petrified forest from this crossing, there's no evidence of that anywhere in this record. And in their opening brief as to the wash, they said all these vehicles turned around due to the road ending at the wash. That is page 6 of their opening brief. There's no question. There's no place to go. There's no reason for anybody, particularly the railroad, to anticipate that there would be anybody other than licensees using this. Secondly, BNSF people on BNSF property are not trespassers by definition. They are authorized to be there. Forest Service people, National Park Service people, who may be using this to gain access to the Forest Service access road that is protected by the locked gate and stop sign, are authorized to be there. That's the state of the record in this case. Arizona law is clear that Arizona follows the distinctions between invitees, licensees, and trespassers insofar as the duty a landowner owes to entrance on the property. And to suggest that there is something different about railroad law is simply wrong, that there's a special set of circumstances that apply to it. In fact, the restatement provisions that Arizona courts have routinely applied to trespasser status are cases that are, if you look at the cases, if you look at the restatement and the cases the restatement provisions rely on and the illustrations they frequently give are railroad cases. So the position that BNSF is advocating here is absolutely consistent with the restatement provisions and with Arizona law governing the duty a landowner owes to trespassers. There's no question that this is BNSF property. There's no question that it is a private crossing. They allege that in their complaint. There's no question that there's no evidence of trespassers. There's no evidence that anybody would trespass, to Judge Campbell's point, absolutely. Bolin is replete with the whole notion that people on the south side of the tracks went across to the business part of the town, back and forth across this routinely. Every jury instruction that the court considered in Bolin had as a predicate finding the jury had to make was that if you find that this path was routinely used consistently and persistently, words to that effect, exactly the continuous and persistent use exception that we find in the restatement section 334. So there's nothing unusual about Bolin. And if you look at Torres, which is admittedly a Ninth Circuit.
Go back to Bolin for a second.
Sure, of course.
The court says this is toward the end of the opinion, it all comes back to the question of reasonable care under all the circumstances. And one of the circumstances is the probability of the presence of persons on the crossing at the time. It doesn't. That statement doesn't say anything about trespassers. I mean, what's wrong with with opposing counsel's argument that, I mean, this really ought to be governed by reasonable care at all times?
I really just don't think that's what Bolin says, and I don't think a fair reading of Bolin can reach that conclusion. If you look at the portion of Bolin that quote is from, and you look at the cases that the case that it quotes, and which is called McCleary, excuse me, and another case called Longino, those are the two cases Bolin relies on in making those statements. Both of those are well-worn path cases. Then if you look at Torres, the Ninth Circuit case that comes after Bolin and says and talks about it, it says, yes, Bolin fits squarely within the well-worn path analysis. And if you read the facts of Bolin, and if you look at what the Court of Appeals was assuming the proper jury instruction would be, because they talk about two of them, they criticized different parts of the jury instruction, but they never criticized the parts of the jury instructions that said you must first find that there is and I can't remember the exact words in front of me, Your Honor, but it's words of, if you find that this is a well-worn path or the railroad knew that people frequently use this path. And that's the difference. And that's a critical difference, and that's a critical difference that is not in this case. And the cases that come after that interpret Arizona law all are consistent with this notion that you have to have a well-worn path. And they simply don't have that in this case. And barring that, Your Honor, we believe that the evidence is clear that then the appellants were trespassers, and that the only duty BNS owed them was the duty not to willfully and wantonly injure them. They haven't argued that we breached that duty. So long as this court follows the well-established Arizona law concerning premises liability, and you follow the facts, the undisputed facts that are developed in this case, I believe you will find, as Judge Anderson noted, that although unauthorized persons could access the crossing, there is no evidence that they did or that there was a reason to do so. That's the point, is that there's no reason for anybody to go there, and they haven't sat here today even and advanced a theory for you as to why anybody would, other than a licensee, other than a licensee or a BNSF person, would be at this location. It is truly in the middle of nowhere, and plaintiffs had to travel 10 miles to get to this location. So those are the main issues. Certainly, we wanted to point out is that counsel could not identify for you any specific evidence of any trespasser. He said he would develop it at trial, except discovery's closed, and we asked all those questions. We argued this motion down below, and there was no evidence forthcoming of trespassers then, and there will be none in the future. That ship has sailed. And there's no reason to treat this as a public crossing because it's simply not used by the public. It is not on a public street. And he suggests this is clearly just private property, and there's no reason to apply any law different than historically Arizona courts have applied.
The average person is supposed to know that it's private property.
Your Honor, there is nothing there that says it is private property. I can say this, it does not look like, it's certainly different than the county road that ended a ways before it. It is plainly a rough, unimproved, basically, where they were driving just before this accident is a one-lane maintenance way road that some BNSF vehicles use to gain access to track. It is hardly something that an ordinary person, I think, would believe is anything but railroad property and railroad premises. But no, Your Honor, there isn't a sign there that says that. Although if a person looks as they drive, they will see that it's gated off as they get further. And in order to get to this premises, when the road ends, there's a fence and on either side of the road, and then there's a cattle guard that they go through.
When they deposed the engineer said that would it be more than half the time or less than half the time you saw cars on this roadway? Honestly, I've seen cars and trucks there and not there. How many? I can't answer. So there is some evidence. How much evidence does he need to show that it's used by trespassers?
Well, we attach the entirety of that relevant testimony.
Says I can't tell if it's railroad or not railroad.
He doesn't
or
know who it is.
forester.
He
Right.
doesn't know if there's trespassers. He doesn't know whether those are the National Forest people. He says certainly a lot of those vehicles that he sees, sometimes he says the majority, then he doesn't even know about that, are BNSF facilities. So, and he doesn't, critically, he says he sees them on the right-of-way road. He's not, or he's seen them on the road. He's not really saying what he saw at the crossing either. So there's a complete deficit of proof as to what he's talking about. And what is absolutely clear is he never says that those are trespassers. And he never says those are unauthorized vehicles or that he has any reason to know one way or the other than he is. And so I simply don't believe that you can take that testimony and rotate it into what they would like it to believe by using a lot of ellipses when they cite it to you. That's why we cited the entirety of it, as to saying that they're trespassers. It just doesn't support that. It doesn't say that.
And in your mind, based on Bolin, based on the restatement, what would we need to see before we could get over that constantly traveled or persistently intruded barrier?
I think you would need evidence to support that conclusion, and it would have to be something that makes sense. For example, in Bolin, the people are separated by a railroad from where they go, and they want to go do the shopping. If you look at the cases that are well-worn path cases, Barry, for example, there's a whole discussion about why people are walking from where they're walking to another point. So the story makes sense, and you have a lot of evidence as to what's happening. In all of those cases, the appellate court is reporting to us that there was evidence of trespassers and what that evidence was. And that's what we don't have here.
You would agree with me that on that day there were the line of cars,
Yes.
and you can see in the pictures there was one on the other side, I believe. Eyesight's not that great. Is that enough?
No, it's not enough, because it has to be daily and persistent use. And what we know of that day is that there were extraordinary circumstances that drove those people to that and those people ended up there because way up on Interstate 10 there'd been some truck fire that had closed the whole freeway down for hours on end, and people were trying to figure out a way around that. I think all that gives us is evidence of, on this day, there were people there. And on that day, those people found there was no, once you went south of that, there was no place to go. And that's all what that evidence suggests, which is, again, sort of contrary to, there would be persistent and consistent use. There would be no reason for there to be persistent and consistent use based on what those people discovered that day, is that they turned right around and tried to get out. So I don't think that changes the analysis at all. After all, this as we point out in our papers, this had a decades-long history of no incidents, no reports of close calls or anything else relating to any problems at this crossing. It is a not particularly heavily used crossing, and it is used primarily by BNSF people and the rest are licensees as far as the record shows. And so there's just simply nothing here that should change the analysis that Arizona routinely applies in premises liability cases. Unless the court has any other questions, I think I've run through the basic analysis. Thank you very much.
Please.
In response to Judge Campbell's questions, the proof problem is the big issue. I have to prove what is in a railroad's mind. Now, we know they reported 55 people a day, so we got time records for employees. And we tried to identify every employee that had ever been at that crossing so that we could count. And in our discovery, they can account for maybe one a day. Well, that's 54 to go. We've got a lady that lives on the other side. We know she's technically a trespasser because the agreements with the forestry department don't include her.
And are we sure there's no independent agreement between her and the railroad?
There is none. The railroad produced none. We asked, we tried, and we couldn't get it. So now I've got to prove the status of the other 53. And from living out in the country in Kansas, I can tell you, sometimes I don't need a lot of reasons to go out on a country road somewhere. There's a lot of people that drive the country roads. That wash itself is a hiking trail. I don't know, and I can't prove what's in their mind. I just don't have the ability to prove what the railroad knew or didn't know. What is incorrect is it is not primarily used by BNSF employees. We do know, and this is circumstantial evidence, and I had to glom onto all I could. We know that there's an entity that lives right there, that great big gas plant, and they put up a sign. Now, this isn't direct evidence, but it's circumstantial evidence. Their sign says railroad access and through traffic. So at least somebody who lives there has put up a sign that tells all of this through traffic to go that way and quit coming into our plant. Now, did they count them? Probably not. I can't do a count. You see the practical issue with allowing a party who has put up a sign and put up a crossing and made this where it is absolutely impossible for a human being that doesn't know this error to know that they have just moved on to private property. It is a golden trap. And when there was a suggestion that it couldn't really be much of a road, well, the video shows those cars going up and down that road over 30 miles an hour. So it's a road. And they were driving up and down a road, and they went for miles up and down that road. All of them. It wasn't some one crazy guy. This was a whole line of traffic seeking that shortcut that Mr. SERONDE's mother had told him about, there being a shortcut. Who all used it? I don't know. We couldn't identify the person in the other car that was on the other side of the draw. All I know is there's a whole set of circumstances, and through proving what we do know that gets us to 2 or 3 people a day, there's 50 unaccounted for. That's why Bolin is so important, because Bolin says, so far as the duty of the railroad is concerned, whether such persons are technically to be classified as trespassers, licensee, or persons using the company's tracks as a right, in all such cases the duty is imposed because of the broad rule of humanity. Is it really the railroad's position that we don't owe a duty of reasonable care to our own employees or the personnel at the forestry department? And if you think you're going to the forestry department but you didn't get permission, do you get in? That old invitee, trespasser, licensee dichotomy doesn't work in this circumstance. And I wanted to quickly go through all of the cases cited by the railroad. Or, by the way, the Torres case is a hitchhiker. And the only reason they talked about constantly and persistently in the Torres case is because the hitchhiker was hit in a location of a derailment where there wasn't any crossing and there wasn't any beaten path. And the court mentions no crossing, no beaten path. The Beasley case was a young man laying on the railroad tracks, not near a crossing or a beaten path. The courts have recognized the dichotomy of you can have crossings or beaten paths. If plaintiff can muster enough proof to show that there's a beaten path, I can at least then get the courts to treat it like a crossing. And that's what the law is in all the other states, and that's why I quoted all the states. Ironically enough, when the railroad's making its argument that this shouldn't be treated as a crossing with reasonable care, they cited cases from Kansas and Texas and West Virginia. And those are the states which we cited. Anytime there's a private crossing, there's a duty of reasonable care. It's that simple. We don't have that in Arizona yet. This is the case that the decision's going to have to be made. And we've got to be consistent with both Bolin and Garcia, which give us if there's an illegal crossing or a crossing where it's not even been recognized, it's a beaten path, we're going to give those people reasonable care. Do we give less care to where we then roll out the red carpet and invite people in? It makes no sense. It makes no sense at all. So, looking most recently, the Delgado case is the last case that they quoted, and this is a guy that's jumping on a train. He's a hobo, and went to jump on a train, and of course, well, we're not going to consider a 5-mile-long yard a continuous trespass on a limited area. You know, it's got to be near a crossing or a beaten path. So, the last case, and we cited in our reply, is Farrell. All of those Ninth Circuit cases deal with no crossing, no beaten path. Farrell recognizes there was a beaten path, and the plaintiff in that case didn't prove much other than there was a beaten path and at least one other person using that bridge. And the Ninth Circuit in that case said, well, you got a reasonable care duty. Thank you.
Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement and issue decision in due course. Thank you.